for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, we will begin argument this morning in Williams v. Morgan State. Mr. Kenny, whenever you're ready, we'd be pleased to hear from you.
Thank you, Your Honors. You may please the court. This case stems from appellant working as the broadcast station manager for Morgan State University. Morgan State University is an arm of the state of Maryland. While working there, she engaged in various whistleblower activities, among them claiming that the university was favoring one of the mayoral candidates in the 2016 Baltimore mayoral election. She also made claims that the university was misappropriating funds pursuant to its FCC license and misrepresenting the use of those funds. Ms. Williams brought a circuit court complaint in the Baltimore City Circuit Court against the university. In that complaint, she alleged various claims. The claims at issue before the court today were under the National Defense Authorization Act, Section 470.
Well, but we're dancing around. The question is whether the state has ever waived its sovereign immunity here. And we're told that in innumerable decisions that waivers of sovereign immunity should be strictly construed. And this goes right to the heart of the state's sovereign immunity, which is the protection of its own treasury.
That's correct, Your Honor.
What makes you think that there's some kind of waiver here?
Well, Your Honor, the case is construing that state sovereign immunity is subject to stringent standards. Generally speaking, revolve around the issue of whether the state has consented to suit in federal court under the 11th Amendment. There's not many cases construing whether or not the state's own legislature has consented to sue in their own state for federal causes of action. And we contend that the Maryland Tort Claims Act, Section 12104.
Why should we as a federal court go charging in to Maryland law and say that Maryland has waived its sovereign immunity? Why? I mean, Congress can abrogate the state's sovereign immunity, and the Maryland legislature can abrogate it, and the Maryland Court of Appeals can abrogate it. But the federal court ought to be the last one charging in and saying to the state that you've waived your own sovereign immunity. I mean, it just gives you the feeling that you want us to go where we don't belong.
Well, Your Honor, the reason why this court is going there is because the state of Maryland removed this case from circuit court to federal court. Now that it's in federal court, it's
But we have indicated that removal, our president has indicated that removal is not tantamount to a waiver.
That's correct, Your Honor. But in that situation, in Lapidus, the court didn't just say, well, we are going to defer to Maryland regarding its own actions, whether it believes its own actions are a waiver. We are now in federal court. This is arising in the context of the constitutional structure, and it is a federal issue. As recently
this Judge Diaz, can you hear me?
Yes, Your Honor.
Okay, sorry. So I think you can gauge from Judge Wilkinson's questions that he has a hesitancy in wading into this area. And I have to say, I did too when I first read this appeal. I was wondering, why we should decide this question. It seems like a fairly weighty question of the state's abrogation of sovereign immunity. And I'm wondering whether anybody at any point considered the alternative, that is certifying this question to the Maryland Court of Appeals.
Well, the appellant hasn't requested that. The court, under the Maryland certification uniform law, could on its own request that.
I know we can. I'm asking you why you all didn't do that, why you didn't suggest that to the district court, why apparently no one has suggested that to our court.
Well, I can't speak for the state of Maryland or why it does not want the state of Maryland.
Do you have any objection to that?
I have no objection to that, Your Honor. I do believe that this is a Maryland issue, but I do believe that this has characteristics of federal law. This court in Lee Thomas v. Prince George's County alluded to the fact that when you have an issue of state sovereignty in federal court.
But the problem is that the by its terms, the Maryland statute waives sovereign immunity only as to tort actions. And this is a statutory cause of action, and it's a federal cause of action. And the state sovereign immunity, why should we extend a waiver of sovereign immunity, of Maryland's sovereign immunity, to a cause of action that is not recognized under Maryland law? And I haven't heard that.
With respect, Your Honor, our position is that this type of statutory employment claim is a tort action under Maryland law. In Waterhouse v. Hopkins, Justice O'Connor.
Well, it's a cause of action under the National Defense Authorization Act.
Well, Your Honor, our position is that Maryland courts, in evaluating the Maryland Tort Claims Act, have routinely characterized the phrase tort to be as broad as, quote, all civil wrongs. In at least two separate opinions by the Maryland Court of Appeals, they quote Black's Law Dictionary, citing Black's encompasses all, the term tort as defined by Black's encompasses all civil wrongs, not just wrongs.
Which opinions are you talking about?
This is Espina versus Jackson, 442, Maryland 311, 2015. And it was also cited in Green versus NBS, 976, A second.
Yeah, but those waivers were of state constitutional claims, not of federal claims. That's what those cases dealt with. And they were all recognized. They were all under state law. They were either state constitutional claims or intentional torts under state law. You're asking us to waive state sovereign immunity for a federal cause of action not even recognized under Maryland law. Why shouldn't we just let the Maryland courts ought to be taking that step, not us?
Well, Your Honor, I have two responses. The first is that in the Green case, what the court did, it applied the word tort to a Maryland statutory claim. And our position is that there's no essential difference in the understanding of the word tort between a statutory state claim and a statutory federal claim. Well, the way they have defined it is the word tort is a broad encompassing civil wrong. And what Maryland has done in several of these cases is say to litigants, when you bring a statutory claim, you must follow the procedures of the Maryland Tort Claims Act, essentially fitting in the statutory claim into the wording of a tort. And that's how Maryland Courts of Appeals have drawn these cases in. And our position is simply, well, if Maryland Courts of Appeals have opened up their courts to a limited sovereign immunity waiver up to $400,000 under certain conditions with certain notice procedures, under the federal system with the supremacy clause and that the law of the United States are the supreme laws, there's no reason why Maryland courts would not fit those federal statutory claims into the same footing.
Impact of the Stern case had, which is the Maryland Court of Appeals case, that basically said that it should construe the solution of governmental immunity narrowly.
Judge Wynn, could you speak up a little bit? Judge Wynn, could you speak up a little? I want to make sure I hear you.
I'm sorry, I realize you're a bit of a distance away. I was asking him to refer particularly to the Stern case, a case in which the Maryland Court of Appeals stated that it would construe legislative dilution of governmental immunity narrowly in order to avoid weakening the doctrine of sovereign immunity. The question really is, does this 11th Amendment have any implications here?
Well, Your Honor, the state sovereign immunity is a creature of both the Constitution, the 11th Amendment, and its own status as a sovereign. To your point, Your Honor's exact point, regarding that decision, there is a provision in Maryland's waiver statute. It's at section 12, and it says this subtitle shall be construed broadly to ensure that injured parties have a remedy. So to the extent that this is asking judicial encroachment on Maryland's waiver of sovereign immunity, Maryland has stated this by their legislature that they want this immunity waiver to be construed broadly. And we don't think it's overbroad to say when you have your courts open to a statutory claim against the state.
Well, there's a difference between construing something broadly and just rewriting a statute completely to open the waivers of sovereign immunity for federal causes of action. And to me, there's a principle of federalism in the relationship between state and federal courts that's in danger of being violated here quite fundamentally by us holding a waiver. As I mentioned earlier, we're the very last ones that ought to be doing that.
Well,
We're the last one.
I suppose, Your Honor, if that's a primary concern, then the certification process to the Maryland Court of Appeals would be the proper avenue to show deference to the sovereign immunity of the state.
Well, but did you ask for certification at the district court level?
We did not, Your Honor, but neither did the state of Maryland.
And did you ask for certification in your brief?
No, Your Honor, but if the state of Maryland itself did not view this issue as sufficiently important to have its own Court of Appeals decide the matter.
So is the deal that you wait to catch the drift of comments from the court and decide you'd be better off certifying?
No, Your Honor.
In other words, if these cases are to be certified, they ought to be certified sooner rather than later, and you ought to be making a motion for certification at an earlier point in time.
Your Honor, that's a fair point, but we've been approaching this case from the posture that the state has decided it wants a federal court to resolve this issue. The state removed this case to federal court. So if we were to then go against what the state of Maryland is saying in this case, which is certify this Maryland Court of Appeals, that seems a little in a positive what the state is actually asking here today.
But Judge Wilkinson makes a good point. These cases come to us in all different ways, and we're all over the world, all over the board of it. Quite frankly, during my time here, I've rarely seen where sometimes the parties don't even think about it. We're the ones that come up with it in most cases in which I've seen certifications go. But I think it's correct. We need to at least begin to establish a direction in which these things happen early, because it takes a long time when we send something for certification. We're not going to get an answer back in a month or two. It may be maybe a year for some of these cases when it comes back. And that notion of certification, Judge Wilkinson's right. It really should be provided early, and we rightly confront you as to why you didn't do it here. Not that it hasn't been done before, but it's something that perhaps we need to begin to direct litigants to do as part of appeal of this sort. Let me ask one question, at least a question that concerns me to some extent in terms of how the district court approached this waiver of sovereign immunity. And essentially, it's been argued that it is to be construed narrowly, this waiver. And I think the appellee will argue that, and I'll ask the same question. My concern is that when you look at the Maryland Tort Claims Act, and this language is interesting, it says, this subtitle shall be construed broadly to ensure that injured parties shall have remedy. How do you, I mean, it seems to me if the district court took the direction of a narrow construction, when the title says broadly, that would be problematic.
I totally agree, Your Honor. And I think it doesn't offend the idea of construing narrowly. When you construe something narrowly in the confines of the statute, and when the statute says take the words of this statute, in essence, and construe them broadly, then I don't think that is an opposite of what the 11th Amendment jurisprudence has been in the district court. And if I may just say one thing regarding the certification issue, This is now the second time that we've been at the Court of Appeals in this case, that this court originally overturned the district court's decision granting the defendant 11th Amendment immunity, and still.
Let me be clear, as far as Judge Wilkins is concerned, Judge Wilkinson, he has answered my question at this point. I want you to know that.
All right, we thank you, and let's hear from Ms. Sheridan, is it?
Good morning, Your Honors. May it please the court. The principle that the court has to begin from in any statutory construction is to ascertain the intent of the legislative body that
Ms.
passed.
Sheridan, before you get to the merits, do you have any objection that the court certifying this case to the Maryland Court of Appeals?
The state has no objection, Your Honor, but we think that this particular case is so clearly not covered by.
I'm not so sure that I agree, frankly, and we'll talk about that, but whether I'm right or wrong, I'm not sure that I'm the best person to decide the case.
Let me ask, I'll follow up and say, if we did certify it, what would be the question you think we should certify?
The question would be whether the Maryland Tort Claims Act waives states' immunity for federal statutory claims. Or it could be a narrower question, is under these whistleblower statutes, because the answer to the narrow question is quite clear.
But do you think the 11th Amendment prohibits us from considering that question?
Considering the question of whether the whistleblower statutes. So I think, the court can construe the state's waiver, if it's clear from the text of the statute, and it's clear, and there's been no by the highest court of the state to the contrary. And what's clear from looking at the statute and that statutes that are in play here is that, and I'm sorry, I'm getting a little bit of feedback, is that the Maryland General Assembly does not consider the type of claim at issue here to be a tort. The Maryland General Assembly had created its own whistleblower statute.
Is there such a thing as a statutory tort in Maryland, under Maryland law?
The only one that I can, well, there are statutory torts like claims brought under the Consumer Protection Act. It's not clear whether that's a statutory tort, but it certainly has elements of tort in it. But that's not something that applies to the state. The state is not a producer of consumer products. The Maryland Fair Employment and Practices Act is actually a separate statute that has elements of torts.
Well, it has its own waiver.
Exactly.
So we would be making that superfluous, essentially, because if the Maryland General Assembly wishes to waive something, it set forth a set of statutory ground rules for waiving it.
Right. And when the Maryland General Assembly creates a new cause of action, statutory cause of action, it expressly states within the statute whether it applies to the state, and it includes within that statute its own separate waiver of sovereign immunity.
The basic problem here is that this is a federal cause of action, and
right.
it's not even recognized under Maryland law.
That is
and for a federal court to say Maryland has waived its sovereign immunity for a cause of action not even recognized under Maryland law, that seems to me to be a pretty bold step. It would seem to me that we've just invaded Not only we've invaded Maryland's house, this is something for Maryland to decide unless Congress abrogates it, which it hasn't.
Right, exactly. That Congress has not abrogated.
Well,
And-
that gets back to my question. If it's something for Maryland to decide, then why not send it to the Maryland Court of Appeals?
The state would have no objection to that, Your Honors, but I do think that in this particular case, it's clear that the General Assembly does not consider these types of.
Why is it so clear? I mean, the language simply says it waives sovereign immunity as to tort actions. There's indication in the cases that at least tort actions under Maryland law include state constitutional torts and some state statutory causes of action. So why is it such a leap to say that a tort action under the state, that the sovereign might also waive its immunity with respect to federal statutory torts? It's not, by definition, a federal statutory tort. It's not part of the state regime, but that's not, I mean, that's just circular. It doesn't really answer the question as to whether or not the legislature or the courts, when presented with this issue, would agree, particularly given the fact that there's separate language in the statute indicating that the whole reason for this statute is to provide broad remedies for Maryland consumers and citizens. So you've got these two competing interests: one, a requirement that sovereign immunity be narrowly construed, juxtaposed against a legislative purpose of the statute to provide broad remedial remedies. And it seems to me an open question. So again, I don't see why I need to be the decider in this case. I'd just as soon let the Maryland Court of Appeals figure it out.
That's a fair position, Your Honor. I would say that the Maryland Court of Appeals has made it quite clear, and look at the statutory structure of the Tort Claims Act, has made it quite clear what the purpose of the act is, and it does have a purpose to compensate victims of tortious conduct by state employees, but it has a twin purpose that is tied to insulating state employees from liability. I mean, that's really it. So the tort claim.
That's a fair statement, but it's also true. Same Court of Appeals, as Judge Diaz alludes to, is indicated civil torts can be rather broad. It actually include statutory type torts there. And so when we look at it from that perspective, and you mentioned purpose, a lot of times I'm not thinking about the court's purpose in doing something. I think about the legislative purpose of it. Is there anything in the legislative history of the act that indicates it doesn't cover these types of statutory?
Well, the thing that shows that it doesn't cover these types of claims, these types of statutory claims, is if you look at the entire statutory structure. So the Tort Claims Act is located in Title 12 of the state government article. The Tort Claims Act is totally within Subtitle 1, and it has it provides a blanket waiver of immunity for tort actions filed in the state, and a coextensive and qualified immunity for state employees. And so the mechanism is that when the state employee has caused an injury and creating a cause of action.
Excuse me, Judge Wilkinson, are you trying to answer the question? I didn't know if you were or not.
No, well, I did have one question here, and that is, has the Maryland Court of Appeals extended a waiver of sovereign immunity to a federal cause of action? Because to a federal statutory cause of action, the waivers that are cited in Espina, I guess, and Lee, all involve waivers to state causes of action. So what I'm asking is there any case in which the Maryland Court Court of Appeals or the General Assembly has waived state sovereign immunity for a federal statutory cause of action. Do we have any case like that?
No, and certainly not under the Maryland Tort Claims Act, which is,
So we would be opening up new ground here in being the first and charging out ahead of the Maryland Court of Appeals. And we would be the first court holding that there was a waiver of state sovereign immunity for a federal statutory cause of action when the Maryland Court of Appeals has not gone that far.
that is correct. Your Honor. That is
Well,
correct.
it's correct.
Now, wait a minute. I'm sorry. Go ahead, Judge Wayne. I'm sorry.
I just want to say, it is correct to the extent that a case of that sort would have gone to the Maryland Court of Appeals. You assume that every case that's filed makes it to the Court of Appeals and ends in an opinion. The fact that you don't have a case does not mean it has not occurred. It just means the Court of Appeals hasn't spoken to it, which goes back to Judge Diaz's point. And I'm very sensitive to what Judge Wilkerson is alluding to here. But sometimes we just get out of the business of the state courts, as much as we like to go ahead and forge on with it. This seems like such an important question that could replicate itself. The Court of Appeals of Maryland really ought to answer this for us, and we give them an opportunity to do so. It seems a very simple proceeding. That's what certification is about. Why wouldn't we just send this to them?
The state would have no objection. And that would be the point to do that. And so I don't know if the state is, if the court is interested in arguing, already decided to do that. I will say,
Do
I will respond to,
you have anything
Judge
further?
Wilkerson.
Counsel?
sorry.
Do you have anything further?
Well, what I wanted, I mean, there are a couple of things I want to point out, which is the main, I want to respond to the idea that somehow the supremacy clause is implicated by the state's argument in this case, because, you know, there's no federal right at issue here. The Congress, in passing the whistleblower statutes, did not give Ms. Williams the right to sue Maryland without Maryland's consent. You know, that's really what this is about, is the sovereign is the one who decides when it can be sued. I mean, that's the essence of sovereignty. And a federal statute cannot do that. You know, unless it's a valid abrogation of state sovereign immunity by Congress. But absent that, it's the state who decides. It's the sovereign who decides.
Let me ask you, does the act really draw any distinction between the state and the federal claims? In other words, is there any meaningful distinction between state and federal statutory claims in Maryland?
Well, they're actually processed differently.
Does the act draw that distinction?
It doesn't specify.
Well, that's the problem. It may well be the case, but we as the federal court drawing such a distinction, the act doesn't have it. We don't have a case from Maryland on it that deals with it. And it's just before us. It does seem like you wouldn't want to go one or the other, but when you don't see that distinction from the act itself, it really is a very important question that needs to be answered.
It is an important question, but I would say that the main concept here is that the sovereign retains control over the scope of the waiver. And the only way it does that is if it's in the position of defining what is a tort. And in this case, it has not defined Ms. Williams's claims as a tort. She sued for wrongful discharge under Maryland, and that was found to be not a viable claim under state law. She could have pursued an administrative remedy under the Maryland whistleblower statute, but that's all she would have gotten is she could have filed a complaint with the secretary to the Department of Budget and Management, but she couldn't sue in state court based on that statute. She'd only have a right of administrative appeal to the court. So she can't, I mean, it has to be that Ms. Williams's interpretation of the Tort Claims Act suggests that the General Assembly just left it to whoever, anybody who wants to define the scope of that, of what a tort is, and to define the scope, therefore, of what the waiver is. And that's just not, it's just not, there's no support for that in any of the cases that have been cited by my opponent. I mean, the cases fall into three categories. There's the Green versus NBS case, which is not about sovereign immunity at all. It's a case about interpretation of a statutory cap on non-economic damages. And the statute in question applies a cap in any action for damages for personal injury. So that doesn't assist Ms. Williams's case at all. The other case, the type of case that she relies upon are the Local Government Tort Claims Act cases. That's the Espina case that applies that to state constitutional torts or state constitutional claims. And if we look at the way the Court of Appeals interpreted those cases, interpreted the Local Government Tort Claims Act in those cases, they did it in such a way as to make sure that that the purpose of protecting the employees was the local government employees was effectuated. And it's really, I mean, it's worth pointing out here that state constitutional claims are not common law claims in Maryland.
Well, the
They're not-
difficulty,
Pardon me?
the difficulty in the plaintiff's position, as I see it, is it opens the door so wide to a federal incursion into state sovereignty. And it would be any time that the federal government created a cause of action, or maybe if it would even apply an implied cause of action, even if it were not a valid abrogation,
Exactly.
just the very act of creating a federal cause of action would automatically open the doors of state court and waive state sovereign immunity. And that just seems to me to pose or to impose some real damage upon our federal system. I don't know why we can't wait for the Maryland court to do it, or for Maryland to do any of these things, but for us to do it strikes me as, I mean, the implications of this are huge. That all the federal government has to do to pull the states into court and to waive the state sovereign immunity is simply to find a private cause of action or to imply a private cause of action. So, and by that, Maryland has lost control over its own court system and over its own treasury and over its own sovereign immunity. That's just not the way our federal system was meant to work.
Exactly, and it results in to read it that way leads to absurd results. Absolutely.
I must agree, at least in terms of the way Judge Wilkinson characterizes it. But I want to point out that that is a construction that would yield what we normally would give as a narrow construction, construing this waiver of sovereign immunity narrowly. The problem is just what Judge Wilkinson describes a legislature can do. And when it enacted this tort law, it had this language: this subtitle shall be construed broadly, which the district court did not do. It explicitly said it wasn't going to do that. And that puts the conundrum back on us. I agree with Judge Wilkinson. I don't want to make a decision to save Maryland. That's why I'm moving in the direction of saying certify this thing to the Supreme Court of Maryland. Let them see it, not us. That's the simple answer seems to be to me.
That certainly one answer.
All right, we thank you. And Mr. Sheridan, Mr. Kenny, you have some rebuttal time.
Thank you, Your Honors. I'll just take a few minutes. First, I am glad to hear that the state does not object to certification. And again, we would not object to certification. I think that will resolve this.
Not a question, do you object? State doesn't object, but do you now ask us to do it? Are you asking us now to certify this to the Maryland Court of Appeals?
Given the tenor of the questions today, appellant would request a certification to the Maryland Court of Appeals. And in light of the fact that the state who brought this case to federal court is now not objecting to that issue. Just want to respond to this.
It is an interesting business. I'm not opposed to certification. What I'm really opposed to is us making a decision that the state has waived its sovereign immunity. I think that would be egregious. But there is a question here about the certification process, which at least avoids the prospect of the federal court charging in and making a major leap in Maryland's waiver of sovereign immunity. And that is that when you don't request it at the district court, and you don't request it in your briefing here, and then you all of a sudden catch the drift of certain things, which you may rightly interpret and you may wrongly interpret. But then, you say, oh yeah, the certification is fine. And I'm just wondering whether, just from the standpoint of certification, which is a far less damaging result than having a federal court charge in with a ruling. But I'm, down the road just worried about last minute certifications, and it would seem to me best thing to do is get it over there sooner rather than later.
Well, I understand that completely, Your Honor, and all those points make sense, and those are all points that are essentially respecting the sovereignty of Maryland. Maryland is on the other side today. At no point during this case have they requested certification. If all those issues that Your Honor just raised, if Maryland did not want this court to resolve this issue, they could have at any point during the two appeals or the district court action made that request. They did not. They are not objecting now, and we would ask the court to certify that issue. And I understand
it seems to me your position at this point is either you argue for certification, or you're going to take the position that perhaps Judge Wilkinson, he may not be alone, says, well, why don't you go ahead and charge into this and see how that works out? Doesn't look like it's going to work out too well for you on that from what I can see. So I'm not trying to direct the argument, but it seems to me there's a clear message coming your direction right now.
And I hear it loudly and clearly, and we would ask for certification to the Maryland Court of Appeals. The one thing I'll say is, this is not the first time that federal courts have come charging into whether or not states have consented to sue. The Supreme Court cases are littered with new exceptions or situations where the federal courts have found state consent. Lapidus, for example, determining whether state action actually constitutes a consent. Alden, Torres recently was a constitutional structure case, but again, the Supreme Court is making that decision about this waiver issue under the 11th Amendment. Finally, I just sum up by saying, I understand Your Honor's concern. Maryland could be opening itself up to additional causes of action by its employees if Maryland employers violate federal law. Maryland did not institute a blanket waiver of sovereign immunity. There's a damages cap. There's a notice provision. There's certain elements regarding punitive damage, regarding different behaviors of the employees that are not covered. So this is not just simply opening the floodgates. This is just providing the employees.
I'll ask you, are there any, I didn't see any cases where you had said that the federal court had said that a state had waived its sovereign immunity, or that Maryland had waived its sovereign immunity for a federal cause of action. And it's interesting that I'm sure that they may have had plenty of opportunities to do so, but they haven't done it. We'd be the first one.
Candidly, I searched and I could not find an example, but that doesn't mean that no state would consent to sue in its own state court for a federal cause of action.
No, but Maryland has not.
Well, I mean, we respectfully argue that the language of the statute includes that type of waiver because Maryland law considers statutory claims to be, in essence, have a tort essence, and the Maryland Tort Claims Act statute, which covers tort actions, is construed broadly. Finally, the last point on this is not an outlandish argument. The Maryland Declaration of Rights, essentially the Maryland Constitution itself, recognizes that the laws of the United States shall be bound, that the state in their own government is bound by those laws in the Constitution, and nothing in the legislature of Maryland to the contrary. So when we talk about, well, this is going to open the floodgates, the laws of the United States are the laws of the citizens of Maryland. And if the citizens of Maryland feel like they've been violated by Maryland's violation of federal statutory claim, we believe that the Maryland Tort Claims Act, up to a certain point, allows them to seek redress. There are no further questions. Thank you.
All right, we thank you, and we appreciate both of your efforts, and we'll go move into our second case.
even if, notwithstanding count 10, the Mr. Robinson is still looking at a life sentence. And I can argue with respect to that causation issue. I would like to address the speedy trial issue, if I may.
You don't really think you can get very far on that speedy trial issue, do you? I mean,
No,
I've never seen one, granted, to be honest with you. I'm not saying it doesn't, it probably should, but they've got a good reason here. But I mean, you've got your brief, you got the
Yes.
argument before us. My question, but I'll lean on Judge Wilkerson, Judge Diaz, if they want to go further. Is there anything you can add to what you've already said? Because if you're just going to repeat it, that's where we are. I'm trying to be frank with you.
yeah,
in terms
well,
of
I
what I'm saying.
appreciate that, Your Honor. I wouldn't have anything else.
All right. Thank you. Mr. Flower?
Good morning, Your Honors. If it please the court, I'm Brandon Flower at the United States Attorney's Office in the Northern District of West Virginia. I'll go directly to the issue that Judge Wynn has addressed, and that is the causation
You
issues
must know this is
regarding
the
count
issue the
10.
court has some concern. Otherwise, we would just send this on back once you confess error. So maybe to further explain why you chose to confess error
Yes, sir.
on that account, it is an interesting situation. And I think if I get it down, it really comes down to the fact that you pursued a method of proving it that really was not the theory that should have been used, should have been but cause. And that just was not put forth for this particular count here. So, you know, and I know there'll be other questions, but I wanted you to proceed on that.
Yeah, you're absolutely correct, Your Honor. And of course, right now, the government's looking at this from a hindsight perspective, but that is correct. We should have pursued a but-for causation in regards to count 10 and the distribution resulting in.
Why do you say that? What was wrong with your previous position? What was wrong with pursuing an independently sufficient cause of death? That seems to the statute talks about resulting in death, and if something is an independently sufficient cause of death, it would seem to me that the supplying of fentanyl resulted in death. And the word, excuse me, counsel, the words, you can't just have any old cause. You can't just have a contributing cause or a peripheral cause. You have to have a cause that is independently sufficient to cause death, to result in death. And the evidence here is overpowering that the fentanyl independently caused, or on its own, independently caused death. You had lay witnesses, you had expert witnesses, they all testified, the jury resolved the question. The judge gave an instruction that fairly presented your theory of the case. The instruction followed from the evidence that was presented. It was given to the jury, and the jury decided this. And so it's just odd to me that you could go through an entire trial with this theory of the case and then come up and at the last minute go wobbly and say we confess error when there's a mountain of evidence indicating that it was the fentanyl. There was fentanyl. There was an independently sufficient cause of death. It resulted in death, and could result in its death and result in death all by itself.
Your Honor, I agree with that assessment. The problem is in the Burrage case, when the court described the two different tracks that could be used to prove the death or serious bodily injury resulting from the distribution of the controlled substance, The court explained that with the independent sufficient cause, there are multiple independent sufficient causes that are required.
What I'm asking you is why is that necessary? If you have, it's probably stronger from the standpoint of the causative agent to have a single to have one independent, independently sufficient cause than to have five. If you have five independently sufficient causes, the causative agent can get lost in a crowd. But here it's when you only have two, you focus in evidentiary terms on those two. But if you have one, why do you need another? The statute doesn't suggest it.
No, the statute doesn't describe which drug, how many drugs, a combination, one drug. But it's the case law. It's that Burrage case that explains.
Let me cut to the chase here. Did you have an expert that testified that but for that fentanyl?
No, we did not.
Did the expert testify that the fentanyl alone did?
No, Your Honor. And that's the crux.
Let me tell you what the differentiation is. Court and bars made it quick. This United States Supreme Court says the courts have not always required strict but for causality, but in certain cases, in rare instances, still rare, you can use multiple sufficient causes independently. And what it is saying is you're not going to have but for. You don't need a but for if you have multiple causes. There's evidence that this young lady had other drugs in the system that could have, maybe, I don't know, we don't know. But what we don't have, it could have been caused by one or the other. It's not like fentanyl was the only thing. Judge Wilkinson is correct. There's a whole lot of evidence that evidence that fentanyl did in fact kill it. That's tremendous evidence. Yes. What you don't have is but for proof. And that's the distinction. Even if you had pursued a but for, but you never mentioned but for, you didn't get an expert for it, it still wouldn't work, whether it's independent cause or not. I agree. The evidence to this court, we want to be the experts on it and say, yeah, but for, she would have died. But that evidence is not in the record that indicate that fentanyl is the cause alone, which satisfies what the Supreme Court calls the strict but for causality.
And that is exactly the point. It's
unfortunate.
The legal standard and the evidence.
It appears as though you could have gone that direction. You just didn't. Quite recognize you did not.
Yes, sir.
But it's that expert, it's the language is right here in the Barrage case. It says no expert was prepared to say that Banks would have died from heroin use alone. That's the problem.
No, and I would
Mr.
say
Flowers, this is Judge Diaz here. I'm sorry to interrupt, but and first of all, let me start by saying I really appreciate the fact that you were willing to go back and take another look at this. It's frankly better that far more lawyers do that because no one is ever absolutely right. And so the fact that you were conscientious enough to go back and reconsider this is to your credit, not to your detriment. So I'll start with that. But like Judge Wilkinson, I just have a real problem understanding what Burrage has to do with this particular case. I think frankly, the court might have been better off perhaps giving a but for a causation instruction. But the reality of the situation here is that your expert didn't use the magic words, but he said, the expert pathologist testified that the fentanyl was in this decedent's body in sufficient quantities to cause her death. I mean, what more do you need? Barrage was a case where no expert was willing to testify that any of the drugs were sufficient on their own to cause death. But here, although the expert wasn't asked the question, he did testify that the fentanyl was in a sufficient quantity to cause her death. This is sort of akin to the example that Justice Scalia mentioned in Barrage, where you have somebody who's suffering from a debilitating injury, right? And that person then is poisoned. And the court said, well, if the poison is administered to the man debilitated by multiple injuries, it is a but for a cause of his death, even if those diseases played a part in his demise. So in this case, we have the diseases being the other drugs in her system that the expert said may have played a part in her demise, but the evidence is uncontradicted that the fentanyl could have killed her and would have killed her. So maybe there was a unfortunate use of language with respect to but for or sufficient cause, but however you want to define it, there's no dispute in this case that the fentanyl would have killed her. So I don't see what the problem is.
Your Honor, I think in my review of this, again, the problem was what the jury was instructed and what we argued wasn't the but for. The jury was instructed on independent sufficient cause. There was no instruction to the jury discussing how the but for would work. But for the fentanyl, she would have lived, or essentially the methamphetamine in her system, or the acetyl.
But there's no evidence in this record that would have been the case. The evidence is clear that the expert said that the fentanyl was in her body in sufficient quantities to kill her. I mean, I don't, you know, I think clearly I don't know if you tried this case or not, but I think that the next question should have been asked, well, with the methamphetamine alone have killed her. And I don't know what the answer to that question is. I suspect the answer would have been no.
And Your Honor, that is, in reviewing the transcript, those were the next lines of questions that could have and should have been asked.
Here's your problem. Expert testified the cause of death was the combined toxic effects of the fentanyl and the meth.
And
that's
that does
the
not
problem.
mean
That's the problem with the independent cause. It's not a but for clause. It didn't say but for the fentanyl, you know, would have been dead. It did not say that was the only one. He said it was a combined toxic effects of fentanyl and meth. That's the major problem you have in this case, and that's why it presents this conundrum for you, because you didn't have that expert say that only. They're absolutely, the evidence is actually correct. It is definitely a sufficient cause. The question is it an independent sufficient cause, which you established by saying, yes, that solely could have done it as one of the independent. That's the missing element here.
Well, Your Honor, in the case, the expert did say that the fentanyl by itself was sufficient to kill her. But the problem is, from my reading of the Burridge case and the explanation of the independent sufficient cause, it requires, it could have also been the methamphetamine. It could have been fentanyl. There has more than one independent cause.
Has the Supreme Court ever expressly disavowed the theory of an independently sufficient cause? I don't understand why there would be this requirement of multiple independently sufficient causes. If you have one independently sufficient cause, that would seem to be enough. But beyond that, has the Supreme Court ever disavowed the independently sufficient cause of death theory?
Not to my knowledge, Your Honor. And I agree with your assessment. From just looking at the facts of the case, it seems
what do you mean disavowed it? It's a different type of theory. It makes it clear that it's not the strict but for causality.
Yes.
It's a different theory altogether.
There are two tracks that the government can prove causation in distribution resulting in death or serious bodily injury. The but-for causation or the independent sufficient cause.
Do you think those are mutually exclusive?
I don't. I think when you look at it, that's why the Supreme Court carved out the independent sufficient cause.
I'm sorry to interrupt you, Mr. Flowers, but when you think about the answer, to follow up with this, how was the defendant prejudiced by what happened here? I just don't, you know, I'm having trouble understanding, even if literally speaking, the court didn't follow the language of barrage. Tell me how in the face of this evidence, the defendant was prejudiced.
Your Honor, my concern is just that there wasn't the proper legal framework for the jury to understand.
That may be, you know, we may have a disagreement about that, but then the question is, okay, assume that's correct. What's the prejudice given the evidence in this record?
Your Honor, from looking at it as from, say, plain error, harmless error, and I would note that was not argued in the briefs. There was overwhelming evidence of the defendant's guilt, that the fentanyl caused the victim's death in this case.
Overwhelming evidence under count 10
Yes,
and overwhelming evidence under a theory that the Supreme Court has not disavowed, and that seems, as far as I can tell, to match up with the statute, which says it results in death. Well, this resulted in death. I
My
mean,
concern, Your Honor,
if the Supreme Court had thrown its disapproval over this, that would be one thing. But I don't see that they have.
Your Honor, my concern is it's not the legal framework or that the Supreme Court has ruled that the independent sufficient cause isn't an appropriate theory. It's the way that the facts were presented in the case under that theory, that they weren't presented in a way sufficiently to satisfy the independent sufficient cause when it would have required multiple independent causes.
Well, they were.
We only presented one independent cause.
Counsel, they were presented in a way that that made it clear this was an independently sufficient cause. I mean, I haven't seen many cases as strong as this. You know, you did a good job. You lined up your expert. He testified exactly along the lines of an independent sufficient cause. You had co-conspirators lining up, and you have somebody carving up somebody's body to throw it into a dump, which indicates he knew darn well what he'd done, and that the China white was what had caused this young woman's death. And you've pursued an independently sufficient cause, which is fine, but the evidence, I think because I don't think the Supreme Court has disavowed it, but the other thing is, under any theory of causation, it seems to me that this would be a very strong case. And given the strength, I also asked the good question that Judge Diaz posed. Given the overwhelming strength of the evidence here, we don't generally think of instructional error as necessarily being reversible error. And one of the things you have to look at is the overwhelming weight of the independent evidence for this question. Was the fentanyl a major causative effort, a major causative agent? And if it was, it did what the statute prohibits, to its distribution to resulted in death. I mean, this is a serious problem that we have here with this drug, and it is laying waste to communities all across this country. And I just can't see weakening what the statute attempted to do. If the evidence was less strong, well, maybe you'd have a better case. But I don't see what you did wrong the first time.
I appreciate that, Your Honor. And I do agree with you that the evidence was extremely strong in regards to the fentanyl causing the death of our victim.
Here's the question. How does this change the sentence in this case?
If the government's position is, if the court finds error and vacates, I think the appropriate thing is a lesser included distribution of fentanyl.
But the overall sentence, how does it change it?
It doesn't change the overall sentence, except there would be one less life sentence. Mr. Robinson ended up with, I believe, 4 or 5 consecutive or concurrent life sentences.
He has 4 or 5 concurrent
years.
life sentences, and there's a danger he might lose one of those life sentences.
That is correct, Your Honor.
In what we're dealing with. So there's no real harm. You know, what concerns me, you were the prosecutor in this case. We're not it. And yet, you were the prosecutor in the case. We're not. You didn't even have to bring this charge in the first instance.
That's
bring it to us, and you look at the fact, and maybe if it had only been the only case, it might be a case you might pursue it more vigorously and says, well, he's going to walk free. This man has 4 remaining life sentences here. If we simply just vacate this and send it back, he's going to be in prison for the rest of his life. End of the day, I don't know, is this going to happen again? You're going to do this again? I'm thinking about repetition of an error. It would be extreme for us in the face of the government confessing error to now collapse these 2 different theories of strict but-for causality and multiple sufficient causes independently, where there's no testimony for an expert of being alone. It would be extreme. I don't know how we write such an opinion. We can, and you know, maybe we will. I'm just saying, but this doesn't seem to be the case to do it. Because there may be a lesson here, don't do this again. And because it just instruct prosecutors that, you got a case like this. If you only got one, put an expert up to see it's the only one and ask for but-for instruction. That cures it. So that cures the problem in the future. That's the value of opinions that effect. And at the same time, Mr. Robinson isn't going anywhere unless something happens with those other 4 life sentences. Do they run consecutively?
concurrent, Your Honor.
Concurrently.
Yes.
Well, either way, well, I don't know how you run a life sentence anyway, much consecutive, but if you run them concurrently, he has all those. There's no indication any of those are going away.
That is correct, Your Honor. Unless you have any other questions, Your Honors, I appreciate your time. Thank you.
All right, Judge Diaz, do you have any further questions? All right, we thank you very much, and we're happy to hear from Mr. Delgatti in rebuttal.
Your Honors, I don't really have anything else to present unless there are any questions.
All right. Are there any questions from the panel? Otherwise, we thank you.
No question.
All right, thank you very much.
Thank you, Your Honor.
We'll go directly into our third case here. Mr. Ferguson, whenever you're ready.
Morning, Judge Wilkinson. I'm ready. Good morning, and may it please the court. Andrew Ferguson representing Dr. Mark Amonette. When direct-acting antivirals first became an available treatment for hepatitis C, Dr. Amonette had to make a decision about how to allocate scarce treatment resources. So he issued prioritization guidelines, similar to prioritization guidelines issued to address the same subject matter across the country in states and in the Federal Bureau of Prisons. The district court held that those guidelines violated the clearly established Eighth Amendment law. That decision was error. The district court failed to define the right at issue with sufficient specificity, and this court should reverse on that basis. The purpose of qualified immunity is to protect officers from personal liability, except in cases where the constitutional issue is beyond debate. The issue in
Mr.
this case,
Ferguson, Judge Diaz, yes, sorry to interrupt you, but you mentioned that the district court found that Dr. Aminetti was indifferent, deliberately indifferent. But I thought what the court found was that there was a factual question as to whether or not the doctor was deliberately indifferent, because a jury could reasonably find that instead of a strategy to deal with limited resources, this was in fact a strategy designed to exclude inmates from treatment. So given that kind of that factual dispute, you're here on an interlocutory appeal. I mean, if we accept that view of the evidence, and we have to, because we can't resolve factual disputes, you know, on that record, isn't there enough to affirm the district court?
respectfully note, Your Honor, for the following reason. This court under Danzer against Sansbury never has to defer to a district court's determination that there's a dispute of material fact. In other words, materiality is contingent on the substance of the right at issue. And if the district court is wrong that a apparent dispute of fact is material, this court doesn't need to defer at all. In fact, it's not supposed to defer. And here, the district court was simply incorrect that the dispute that it conjured was material because it's wrong about the Eighth Amendment. The Eighth Amendment requires a plaintiff, in order to prevail, and at summary judgment, they have to be put to the burden of their proof. In order to prevail, the plaintiff has to show that the defendant knew of the substantial risk, knew that the acts the defendant undertook to address the substantial risk were so woefully short that they shocked a conscience, and yet proceeded anyway. The district court flipped the burden of proof, same way that the district court did in Hoffer against Florida Department of Corrections, where the 11th Circuit reversed. The district court said, well, look, there's a dispute about whether Dr. Aminette had sufficiently tailored these prioritization guidelines to the shortages in the prison system. That is the backwards way to do an Eighth Amendment claim. To prevail on an Eighth Amendment claim, the plaintiff needs to show that Dr. Aminette, in fact, knew the guidelines were insufficient in light of
Mr. Ferguson, before we even get into the deliberate indifference, position is that there's a threshold question of law, not a dispute, not a question of disputed fact, and that the threshold question of law is whether the district court framed the right in sufficiently specific terms. And what the Supreme Court has told us time after time after time again, and what multiple courts have said, in order to give a defendant notice as to what behavior is permitted and what is not, the right alleged to be violated has to be framed in specific terms. As I understand it, that is a question of law, whether it's framed at a sufficiently specific level. Is that correct?
That is absolutely correct, Judge Wilkinson. And if I'll elaborate, it is absolutely correct. The Supreme Court has been elusively clear, particularly over the last decade, that in qualified immunity cases, the right has to be defined with sufficient specificity in order to vindicate the interest that is the purpose of qualified immunity.
And that's a threshold issue. Before you get into deliberate indifference, that's a threshold issue.
That's absolutely right, Your Honor. After Pearson against Callahan, this court can choose to address the qualified immunity defense either by addressing the clarity with which the right was established at prong 2 or the right itself at prong 1. So unequivocally, the clarity of the establishment of the right can be a threshold question, and we think it is sufficient to reverse the district court. I only address it.
Excuse me. If we decide, if we were to go the qualified immunity route, you have to be something. There has to be something more specific than saying, well, there's an Eighth Amendment right to adequate medical care, or whatever. Because once you get into that, that's as broad as all outdoors. That could mean anything, adequacy, or what have you. And it seems to me, though, that under the Supreme Court's decisions, they've done two things. Number one, they've required that the right be framed in a very specific manner, and that is a question of law, and that is a threshold question. That's the way I understand the analysis to go. And a lot of when it's framed as a specific question about the right to treatment with DAAs, there have been multiple courts that have rejected that there's the specific right, that specific right exists. And courts are getting reversed right and left on this qualified immunity ground for a failure to first frame the alleged right that's violated in sufficiently specific terms.
I agree entirely, Judge Wilkinson. A cottage industry at the Supreme Court has emerged over the last 7 years of having to summarily reverse courts of appeals who fail to frame the right with sufficient specificity. The framing of the right is important because qualified immunity is intended to ensure that officers have fair notice of their constitutional obligations when they undertake official conduct. That is particularly important to someone in Dr. Amanat.
One other thing I wanted to ask you. It seems to me that the Amanat and Wang are in somewhat of a different situation. As far as Wang is concerned, it seems to me he was more intimately involved in the treatment of this individual, and it might be that a deliberate indifference analysis, whatever, is more appropriately applied to him. But as to Amanat, it seems to me that a qualified immunity analysis is more applicable to him. It just seems to me that the specificity issue that you frame is more compelling as it relates to Amanat, and then when you get into Wang, you have to ask the more factually laden question about whether there was a disregard of a known medical risk, conscious disregard of a known medical risk. But don't the defendants go off in different roads here?
Judge Wilkinson, my time has expired. I assume it's okay if I answer your question.
Yes.
So I will leave the specifics of Dr. Wang's case to the Principal Deputy Solicitor General who will argue after me. But I will say this about this potential dichotomy. Qualified immunity is most important with regard to officers in Dr. Amanat's position who have to set system-wide policies for a wide range of situations. The whole point of qualified immunity, as this court has said, is to impose personal liability for the breach of bright constitutional red lines, not for decisions made in difficult gray areas. That is precisely the situation that confronts a system-wide administrative official like Dr. Amanat when there are new treatments and shortages of available treatments, and qualified immunity needs to be applied most robustly for officers.
All I'm asking you is a simple question of whether the qualified immunity analysis you're putting forward may be more applicable to Mr. Amanat, Dr. Amanat, than it is to Dr. Wang. Dr. Wang raises, it seems to me, a different kind of question. You agree with that?
I do think that the application of the Eighth Amendment and therefore the application of qualified immunity will differ when you are comparing a treating physician who's actually attending a patient against a system administrator like Dr. Amanat.
That's what I'm suggesting to you.
Yes, I think that although the rights should be framed similarly because the rights are implicating the same issues, the analysis will not necessarily be the same when you're considering a treating physician and a system administrator like Dr. Amanat. And
all right.
Mr. Ferguson, I'm sorry, before you sit down.
No, Judge Diaz, did you have a question?
I do, yes. So, Mr. Ferguson, how would you have the court, how do you think the district court should have defined the right with respect to these particular drugs and the administration of these drugs?
The position that Dr. Amanat has taken in his briefs is that the right is best defined as the right to receive DAAs if you are diagnosed with hepatitis C. I do think that that is the right way to frame the right because this treatment was so new. It was a dramatic departure from the way that everyone in the country had been treating hepatitis C because of the recent arrival of the drugs. I don't think that a officer could fairly have been on notice of anything more than that, which is why framing the right with this sort of specificity is important.
Well, and I appreciate that because obviously there's a balancing act here. You don't want the right to be framed too generally because that's unfair to the officials. But on the other hand, if the right is framed too specifically, then effectively you have to wait until a court decides that a precise medical condition and symptoms are issue are in play, and that's unfair to the inmate. So in this case, I mean, we got past the question of whether or not these drugs were appropriate treatment. The question is whether or not the doctor, your client in this case, appropriately administered those drugs in the manner in which he set up the program. And from the district court's perspective, I go back to my first question. The district court in this case suggested that there was a disputed issue as to whether or not this was a system designed to harness and most effectively use limited resources, or whether the doctor intentionally deprived inmates arbitrarily of the right to treatment. And framed in that context, I don't see why why that isn't an issue for the jury.
With respect, Judge Diaz, again, I'm not taking issue with the alleged dispute of fact. I'm taking issue with the district court's determination that the dispute is material, which is purely a question of law, because materiality turns exclusively, of course, on the content of the right at issue.
Well, how couldn't that be material?
Because what the district court said is, I believe there is a dispute because Dr. Aminette didn't put on evidence that he knew exactly how many patients had hepatitis C in the Department of Corrections system, which is also wrong as a matter of the record. But setting that aside, that he didn't know how many patients had hepatitis C, and he wasn't aware of how many primary care physicians could prescribe the DAAs on the ground, given that most primary care physicians did not have facility with administering DAAs. And the district court is simply incorrect that that is the relevant Eighth Amendment question, because it flips the burden of proof exactly the same way that the district court did in Hoffer against Florida Department of Corrections, and on which the 11th Circuit reversed the district court. The question in an Eighth Amendment case is, did the defendant know of the substantial risk, know that the measures that he or she was taking were so woefully insubstantial that they shock the conscience, and proceed anyway? The district court's holding as well, there's ambiguity about how much he knew. If there's ambiguity about how much he knew, the Eighth Amendment claim fails because knowledge is the necessary component of the Eighth Amendment.
All right. Thank you, Judge Diaz. Did you have any further questions? Judge Wynn?
No, not. Thank you.
All right. Let's hear from Ms. Maley.
Thank you, Your Honor, and may it please the court, I'm Erica Maley representing Dr. Lawrence Wang. I'd like to begin, if I may, with an issue that's particular to Dr. Wang, and that is the question of sovereign immunity. The Supreme Court of Virginia's recent ruling in the Patterson versus Danville case, which we submitted in our 28J letter, makes clear that Dr. Wang is entitled to sovereign immunity on the medical malpractice claim. Patterson instructs that courts should look to the case with the closest factual parallel. And in this case, that's clearly Patterson itself. Just like this case, Patterson involved a doctor.
Well, I understand that, and they've got in terms of the Patterson case, which also applied to Dr. Wang. But why don't you go into the question of whether there was deliberate indifference under the facts here in terms of the federal cause of action?
Certainly, Judge Wilkinson. As to the qualified immunity analysis, the prong two that Dr. Aminette's counsel was addressing does overlap a good deal with the claims of Dr. Wang, in that the right was applied the same way to both of them, and for both of them, it was defined at far too great a level of generality. There is also in that.
Dr. Aminette was at a level, he's the chief physician here, and he wasn't involved in the treatment of this particular individual. And he didn't really get into this, as I understand it, the specifics, case by case of when someone would warrant an FIB score or an FIB scan, and when they were not, and he didn't hold the individual sessions with this inmate. And so it seems to me that the two defendants are differently postured here. That doesn't mean you lose. It just means that I think you need to argue your case in terms of deliberate indifference and the way in which that differs from a negligence standard, and why Dr. Wang's behavior may have been negligent. He admits he made a mistake, but why that doesn't rise to the level of deliberate indifference. Now, why don't you go and tell me what Dr. Wang did with respect to this individual inmate?
Just as you said, Judge Wilkinson, he did make an error. He confused two of the aspects of the Department of Corrections guidelines. There was separate cutoff points for the APRI score, which was 1.5, and for the FIB-4 score, which was 1.45. And he got those numbers confused and mistakenly believed the cutoff.
Ms. Malley, can I ask you about that? So in response to that, the district court said that your client, Dr. Wang's defensive mistake hinged on his credibility, whether or not in fact this was a mistake, which the court said was not appropriate to consider on a motion for summary judgment. And so again, this raises the same issue of whether or not this kind of factual dispute, credibility dispute, is appropriate for us to consider on an interlocutory appeal.
I think the Danzer versus Stanberry case that Mr. Ferguson was discussing is highly instructive on that issue as well. And Danzer was similarly an interlocutory appeal that involved questions about the officer's mens rea. And the court in that case held that this court can look at the facts in the record that the district court considered and any other undisputed facts in addressing the legal question of whether that demonstrates the required mens rea of deliberate indifference. And we're asking the court to do the exact same thing.
Well, okay, so if we do that here, I mean, the record suggests that on 3 different occasions, your client, basically ignored the guidelines that would have suggested that this inmate should have gone, at least this is from the plaintiff's perspective, 3 different occasions, ignored the guidelines that would have suggested further testing on the part of the inmate. And then when he did finally order the testing, the fibroscan, didn't follow up until I think over a year had passed before he finally got the test that he had ordered initially. And so why couldn't the jury find that on those facts, those repeated omissions amount to deliberate indifference?
Respectfully, Judge Diaz, that's not quite correct. There were 2 occasions on which he was slightly over the 1.45 cutoff.
Well,
but under
I want to make sure, I want you to minimize that. I could take off a banner that has been taken off in other instances on how bad the situation this is. Man's in prison. He has this hepatitis C. He is entitled to this treatment. The doctor comes up and says he makes a mistake. Well, his mistake cost this man his life. And I mean, it's right there. He's entitled to it. So I don't minimize it to say, well, maybe not 3 times or whatever. The fact of the matter is that treatment is there. That level of treatment has been proven to be quite effective. But by the time you got to this man, it's too late for that. That's the case we just handed down in June on Ford versus Clark. I think that has some applicability here. And when we begin to look at the particularization needed for Fourth Amendment cases, Clark made it clear that's not necessary for Eighth Amendment type cases. And Clark even goes further in terms of talking about deliberate indifference in the context of what we're talking here. But at the end of the day, no one says your client wins or loses. It goes back to Judge Diaz's point when you were talking about credibility. Why would we go there? That's a jury determination.
Respectfully, I don't think it is a question of credibility, and that's because deliberate indifference is such a high standard.
Didn't the trial court say so?
The The trial court did say so, but that is an error of law considering what deliberate indifference requires. It's akin to criminal recklessness, and it requires that he must have been actually subjectively aware that there was an excessive risk to Mr. Fowler, and he must have actually been subjectively aware that the medical care he was providing was inadequate in light of
Well,
that
if
risk.
we look at the objective evidence here, you got the guidelines right in front of you. Doctors should know what guidelines are, particularly when you're dealing with something serious as this. He said, I made a mistake. And you said that can't be credibility. There's some just objective factors. That's not true. It's not a matter of his credibility as to whether, in other words, we have to believe it. Do we? Do we have, is it necessary just because he said he made a mistake, does that end it as a matter of law?
In these circumstances, it does, because there is no evidence that could show that it was done deliberately with actual knowledge.
Not many cases of this type show that. Not even medical malpractice cases, but when you got the medical guidelines that any standard of practice says you ought to know what it is in treating these kinds of patients, and you overlook it twice and deny him treatment, what more do you need?
In a deliberate indifference standard, it's not a question of what a reasonable doctor would have known or what he
Well,
ought
we're not
to
doing a medical malpractice case. I got that. But we are doing one that deals with credibility of the witness. All we're saying is the evidence of his word saying it's a mistake would simply say anybody that's in this situation, all you got to do is just say, no, I made a mistake. That's the end.
This court has held in a number of cases, including Parrish versus Cleveland, that when you don't have direct evidence of the knowledge and you're inferring it from the obviousness of the risk or the error, then it has to be so obvious that you conclude that he had actual knowledge because he couldn't have failed to have actual knowledge. And that's just not the case here, especially considering Dr. Wang was a generalist. He wasn't an expert in this area, and the standards were new and they were complex.
Well, you're very forceful, but I think the case does indicate quite conclusively if there's an issue of material fact, and that key fact that we're talking about, and establish that fact on his credibility, remaining as to the difference, then the question is, does it affect his serious medical needs? That's the question, is there material fact? That fact is based upon someone's word, and the court, this court says it's credibility.
My time is expired tonight.
Yes.
We're not disputing in this interlocutory appeal that there was a serious medical need. The question goes to whether the record was such that properly construing the deliberate indifference standard, there was a material dispute of fact. And our position is under these facts, considering how high a mens rea that is, that there is not. Thank you.
All right. Thank you. We would now like to hear from Mr. Sherman.
May it please the court. Good morning. It's John Shulman on behalf of the estate of Danny Fowler. Mr. Fowler died in prison, died in a cot, in a gym, in pain, unnecessarily. He went into prison in 1999 with hepatitis C, had been dealing with that, had been treated for that. And then it gets to the point in.
Well, we know the facts. Why don't you go to the issues that we've discussed?
I'll go straight to the one.
Particularly, go to Judge Wilkinson's question regarding positions we take with Wayne and as to Amaret. Do they differ insofar as our analysis on sovereign immunity?
No, Your Honor. On the strict legal question of the threshold question as to the right that was violated, if you'd like, I can discuss Dr. Amonet's position in terms of his deliberate indifference, because with all respect to counsel, it wasn't an issue of prioritization. The district court just refuted.
But they do differ. At least it's facts and circumstances do differ somewhat, don't they?
Well, of course, Dr. Wang was hands-on treating physician.
Doesn't that make a difference?
Well, it doesn't make a difference, I believe, to the to the fact that both were deliberately indifferent. They were deliberately indifferent.
It's got to make a difference, counsel. They were totally differently situated, and what Dr. Amonette was doing was taking a novel treatment, and he was trying to set priorities, and it's a very detailed set of priorities here, and he had to allocate a set of scarce resources because, as I understand it, the VCU or the new clinic or the medical college of MCV clinic didn't have an infinite number of openings. So he was trying to set up a system. As I say, he's plowing somewhat novel ground, and the whole purpose of qualified immunity is to provide this man notice, and he's not provided any notice by the fuzzy general comments that the district in which the district court framed the right, and we're going to be marching into a nest of machine gun fire if we deny this individual qualified immunity, because multiple courts have rejected the idea, a number of them, that there's a specific right to treatment with DAAs or the antiviral, and the Supreme Court has said you've got to frame this right with specificity, and he's trying to set up a system here, and to the best of my knowledge, I can't understand why the system was in any way deficient. Now, it's a different question, raising different issues as to whether the system was properly applied. But there's a whole lot of difference here in terms of this case between someone who is the treating physician and dealing with this individual on a day-to-day basis and someone who is setting up an overall system for the allocation of a scarce medical resource. And they simply, however it comes out, they simply implicate very different means of analysis. And all I can tell you is if these have not just been reversals, they've been summary per curiam reversals, where courts of appeals and district courts have failed to frame rights in sufficiently specific terms. Now, Judge Diaz makes an important point, I think, and that is that you can't insist on so much specificity that you have to wait for a court to rule on all fours or with an identical set of facts or whatever. That destroys the balance. But surely something more was due this doctor, and I'm talking about Amonette here, which raises different questions from Wang. Surely something more was due by way of notice for this individual than was given by the way the district court framed the right. That's what I'm saying, is that in the balance between generality and ultra generality and ultra specificity, this seems so clearly to me in the case of a novel medical treatment to fall on the too general side of the line, because anybody can say, oh, well, the Eighth Amendment protects the right to adequate medical care. The Fourth Amendment protects the right to unreasonable searches and seizures. The First Amendment protects the right to free speech. And you have to do something more than that. And I think pitifully little more was done in the case of Dr. Amonette. Dr. Wang is a closer question, but it's there. The difference is the fault line between negligence and deliberate indifference, and where on that fault line Dr. Wang falls. But I just think the case against Aminette is singularly weak. And I just say, looking down the road, it's going to be a rough ride with these kind of cases when they, if and when they go up to the Supreme Court.
Yes, Your Honor. Thank you. And if I could just, as you suggest, focus on what the district court found to be a dispute of material fact in terms of deliberate disregard of Dr. Aminette. The district court found it was a genuine issue of fact as to whether Dr. Aminette's system, the guidelines, were an act of prioritization due to limited resources or an exclusionary guidelines, exclusionary, because in the record, Dr. Aminette said there was never any financial constraints on him. He could get all the money he needed and he could move money from.
How could they be exclusionary? They set up numerical guidelines and test score cutoffs that were meant to be applied generally.
Well, as the lower court found, Your Honor, there was a disputed fact as to whether it set up a system where you could not get treatment unless you got sick. Now, it's not in 2018. These
It's not a disputed factual issue. With Wang, you can make the argument that it is, although there's a question of negligence versus, but this is a qualified immunity in terms of adequate notice provided. That is a question of law.
Yes, Your Honor. And the notice that the district court found was that the prisoners have a right to adequate medical care to be free from officials' deliberate indifference to their known medical needs. And that applies to Dr. Aminette because at the time of this event, these direct-acting viral drugs were not all that new. The National Association of Liver Diseases, they'd already changed their guidelines long before that. And they said it's best to get treatment at an early stage, not a late.
That's fine, but there is nothing here that speaks to a right to treatment with DAAs or to antivirals for hepatitis C.
Right, and
there's just nothing. There's nothing that addresses that.
And the district court relied on the Cinto case. Cinto, I think I'm saying that correctly. The Cinto case from this court, where they followed the Supreme Court in El Kid, where El Kid says that you cannot have a high level of generality, but it must also is improper. But it must also have a right to be need to define a case directly on point. It's too difficult. In the Cinto case, it was an inmate who needed an insulin shot. Well, he needed two things. On one hand, he needed an insulin shot. On the other hand, he needed medical care when he was in lockdown in an emergency situation. So the proposal from the defendants in that case was that the contours of the right should be that the prisoner must receive an insulin shot when he needs it, and the other contour was the prisoner must receive emergency medical care when he's in lockdown when he needs it. And those were just found by this court to be far too specific. When the contour is tailored to the very action in question, it just opens the door to the fact that no official would ever be under notice unless it's the specific act in question, and that would be unworkable.
But you've talked about adequacy, and you've talked about early medical treatment, and this and that could apply anywhere. What you're talking about here are medical professions trying to set up institutional guidelines. And as I understand it, these institutional guidelines apply to all inmates. Is that correct?
Well, these specifically apply to inmates with hepatitis C.
Okay, but how could they be exclusionary if they apply to all inmates with hepatitis C? I mean, they seem to me that those standards were framed in a neutral way, in an objective way, and dependent upon test scores.
Because, Your Honor, these new drugs, and I say new in the sense that they were being rolled out, but they've been around for a long time. And the benefits of these new drugs were recognized by everybody, including Aminette. These drugs were not accessible to an inmate in the Virginia Department of Corrections until they reached that certain level. Well, that certain level was too high. You couldn't get there until you were so sick that the drugs may or may not help. So it was exclusionary in the sense that you were excluded unless you were sick enough to get it. But in fact, the medical evidence that Dr. Aminette was aware of was that you should get it at a very early stage. And it's not prioritization.
These are complicated medical judgments. Where do you think the cutoff should have been placed with respect to the FIB-4 category and the APRI cutoff? Suppose, put yourself in his shoes. Where do you think the cutoffs would have been? What numbers would you have substituted?
Well, I would have followed, and I'm obviously not a medical professional, but I would have followed the guidelines of this Association of Liver Disease, the ASDLA, which had it about 1.2, which showed that if there's any, so these FIB scores, what they do is they measure scarring in the liver. So I would say if there's any scarring in the liver and these drugs are so effective at an early stage, I'd say give it to the person to save their life, to prevent complications, and down the road to prevent further healthcare costs. So that's what I would have done, but that's, but in any case, in terms of, it's what the court found was a genuine issue of material fact as to whether it was exclusionary or whether it was a prioritization. And it used several factors, including the fact that the system where there was a prioritization because of resources, I think it was used in the federal prison system, they actually had a committee to review decisions and to make sure that cases that needed it were not subject to the prioritization. So that wasn't applicable. But getting to Dr. Wang, if I may, for a couple of minutes, that there is a different disregard issue, because Dr. Wang, as the court below said, he essentially turned a blind eye to these tests, one after another. You know, everyone makes a mistake, but you make a mistake the first time and then you repeat it a second time. And then when the mistake is found and time has passed and this man's condition is getting worse and worse, you don't then put him to the front of the line for these 5 scans. I mean, that's deliberate indifference. And the test.
Well, he was treated. I mean, he was tested repeatedly between April 2015 and May 2018. He had blood tests at least 6 times. And as I understand it, the difference between negligence and deliberate indifference is that you have to recognize that human beings are not infallible. I wish we were infallible. It would make life a lot easier. But human beings make mistakes. And in the vast run of cases, those mistakes occur through negligence. But you can understand how the mistake was made here, because the FIB cutoff for the second category was 1.5, not 1.5, not 1.45, which was the same as the APRI cutoff for the first category. So did he make a mistake? Yes. But is that a conscious disregard of a known medical risk? I mean, the very definition of a mistake is that you put it into the category of a negligent infraction. And when you look at Estelle v. Gamble, it made so clear that deliberate indifference was a different standard from negligence, and yet somehow in the lower federal courts, the standard has bled into negligence. And I'm wondering if this isn't one of those cases, because if he tested him repeatedly, he saw him repeatedly, when the on the third visit, Wang ordered a fibro scan with ASAP instructions. So you can quibble with it, but I wonder whether there's a conscious disregard of a serious medical risk, or whether it belongs in the large category of unfortunate human behavior that we talk about as negligence.
Yes, Your Honor, and what the court found in this case, what the district court found in this case, was that there was a genuine issue of fact on this point, a triable fact, because there was the first instance of making the mistake on the readings, and that was his job to use those guidelines. The guidelines were right before him.
Where was the conscious disregard of a known medical risk? Where did he just consciously disregard it? That's what the standard is.
Right. Well, I think that the circumstantial evidence of making that mistake twice goes to conscious disregard. And then in the third instance, he was referred, but in the period of time before he actually finally got his scan, he saw Dr. Wang again, and Dr. Wang didn't even follow up with him to sort of move that forward. He didn't get there was a 3 or 4 month period that passed where Dr. Wang did nothing after the first referral. I think that's comes closest to conscious disregard, and I think that's why the court below found that in fact there is a genuine issue of material fact that should go to a jury on that case. And I would say that that's the appropriate forum. It should go to a jury, and a jury should determine whether that standard of deliberate indifference has been met, or whether it is negligence. But I think that's truly a fact question that the court has described. The legal question as to whether the contours of the right whether Dr. Wang was on notice that he was violating a right, I believe that the right articulated by the district court is appropriate. It's not so general. It's not specific.
As I understand it, Mr. Fowler was given diagnostic tests over the course of his treatment that included a fibro scan and a liver ultrasound and an abdominal CT scan, liver biopsy, and MRI. I mean, there are many, many patients who are dissatisfied with their course of medical treatment.
I think in this case, because of what we characterize as the deliberate indifference of Dr. Wang, by the time Mr. Fowler got his scan, by the time the VCU clinic was able to assess the scope of scarification of his liver, well, then the specialists were brought in, and it was determined that he had terminal liver cancer. That could have been prevented. That could have been prevented by use of the direct acting.
Dorman, Judge Diaz-Vieira, sorry, before your time runs out. There are easy cases, I suppose, where deliberate indifference standard can be met. I mean, if Dr. Wang had done absolutely nothing in the face of a diagnosis of cirrhosis, that's an easy case. But Judge Wilkinson's point is that all along this course of treatment, he was treating him and doing things within the realm of professional medical judgment. And on two separate occasions with respect to the misdiagnosis of the guidelines, and then the third time when he failed to follow up promptly with respect to the tests that he had ordered, I guess the question is whether or not those 3 instances, taken in the context of the broader treatment that was afforded to your client, whether that actually raises a genuine issue of material fact for a jury to decide.
If I may, Your Honor, I know I'm out of time, but
yeah, please.
I think it was addressed in the Gordon v. Schilling case. Monitoring is not treatment. Monitoring this man because he had Hep C since 1999 is not treatment. When it came down to the point where he desperately needed treatment, the deliberate indifference of Dr. Wang foreclosed him from getting that treatment early because he didn't calculate that he didn't realize he hadn't read the guidelines, or he didn't realize what those guidelines required him to do. And in the third instance, where he just ignored his own prior report, didn't send this man on, who at that point had visible symptoms, fatigue, swollen stomach, and elsewhere. So, Your Honor, if you have any further questions,
Judge Diaz, do you have any further questions? Judge Wynn, do you have questions?
No, Judge.
thank you.
All right. Thank you very much. And let's hear from Mr. Ferguson because he has some rebuttal time.
Thank you, Judge Wilkinson. I'd like to make two brief points. First, my friend on the other side's brief repeatedly refers to the right in this case, that it should be defined as the general constitutional right to be free of deliberate indifference. That is precisely the sort of right definition that the Supreme Court has consistently summarily reversed courts of appeals for relying upon. Second, my friend on the other side relies on the Skinto case, or Sinto, however it is properly pronounced, as having clearly established the right at issue at this case. That's wrong for two reasons. First, I think that the court should pay careful attention to the facts of Skinto. The facts in Skinto involved a prisoner left in his cell, vomiting blood, begging for help, and was denied any medical treatment of any kind for 2 days. That is not anything approaching the allegations against Dr. Amonette, who was setting system-wide prioritization policy for a Department of Corrections with tens of thousands of inmates. Number one. Number two, I think that this dispute over Skinto and over the right definition, I think that gets to an important point that Judge Wilkinson raised earlier. My friend on the other side, for example, said that he would draw the lines for FIV4 scores at a different place than Dr. Amonette drew them. He said, for example, a committee should have been used to make treatment determinations rather than individual doctors. Qualified immunity protects officers from personal liability for violating right-line constitutional rules, not for making discretionary determinations within constitutional gray areas. That is precisely what is at issue in this case. And unless the court has additional questions, we ask that the judgment of the district court be reversed.
Thank you. Ms. Maley, let's hear from you.
Thank you, Judge Wilkinson. I'd also like to make 2 points. And first, I'd like to point out that my friend on the other side did not dispute in response to our 28J letter and has not disputed before the court today that Dr. Wang is entitled to sovereign immunity on the medical malpractice claim under Patterson versus Danville. And second, as to the 8th Amendment claim, I agree with Judge Wilkinson's observations that there is a very long spectrum between negligence and deliberate indifference. And in this case, there is all the evidence shows that once Mr. Fowler's scores passed that 1.5 cutoff, which Dr. Wang mistakenly believed to be the cutoff under the guidelines, he did provide quite a lot of medical care. He referred him for the FibroScan test. He prescribed.
Rally, sorry to interrupt you, but do you disagree that deliberate indifference can be shown by circumstantial evidence? I mean, it's not often the case that you would have a claim of deliberate indifference shown by direct evidence. So that's the whole point of this case, is that the plaintiff is saying that, sure, there's no direct evidence that Dr. Wang was deliberately indifferent, but look at what he did or didn't do. And that's enough, at least, to get to a jury.
We agree that deliberate indifference can be demonstrated through circumstantial evidence, but it can't be demonstrated just by speculation. And this court's decision in, for instance, Paris versus Cleveland is instructive. If you're inferring deliberate indifference just from the fact that a reasonable person in those circumstances ought to have been aware of the risk, then you're turning the deliberate indifference standard into a negligence standard. And it's never been a negligence standard, and it's not intended to be a negligence standard. So there has to be something more than that. There can be cases like Skinto is an example where it's just so obvious that someone was in immediate need of medical attention, that in that case he was vomiting blood in front of the doctor, that you can infer it from the obviousness. But this isn't.
Ms. Malley, sorry. So that's an obvious case, but does it need to be that obvious?
It's always a subjective standard. So it's not as though there's a certain level of obviousness at which it can be imputed. The question is always, what did this individual doctor actually know? And at a certain level, as in Skinto, it can be inferred from the obviousness because it's impossible that he could have failed to realize it. But that's not the case here. It's very easy to understand how he made the mistake that he did. And Mr. Fowler at that point was not showing symptoms of liver disease that would have obviously put him on notice of.
So let me say I grant you that, but in the face of that, how do you explain then, why couldn't a reasonable jury then decide, well, on top of that, after he orders a test, recognizing that he twice missed the cutoff of the guidelines, just doesn't follow up until a year later?
He did follow up, Judge Diaz. He followed up 2 months later. And at that point, he said, please schedule him for the FibroScan test ASAP. And that makes this case quite different from, for instance, the Bjorn case where the doctor never followed up at all, even though a year passed. And in the meantime, he was prescribing him medications to treat the condition. He referred him for an MRI test as well once the results of the FibroScan were concerning. So you can certainly say there was more he should have realized what should have been done. But in terms of saying what is the evidence that he actually knew that the medical care being provided was inadequate for an excessive risk, there is no such evidence here. And for that reason, qualified immunity should.
I think the key word here is that for the deliberate indifference standard, it has to be a conscious disregard of a serious medical need. And I come back to a conscious disregard. And what separates deliberate indifference from negligence is that negligence doesn't have that kind of mens rea. It's in mens rea terms, it's totally different because negligence is sloppiness, but there's nothing intentional about it. But deliberate indifference phrased in terms of conscious intentionality and is a different level of mens rea entirely. It can't be sloppiness, it can't be negligence. It has to be, as the standard is phrased, a conscious disregard of a serious medical need. And there's nothing about Dr. Wang's behavior that rises to the level of a conscious disregard of this individual. It's just not there. And the cases where deliberate indifference has gone to a jury are without variation significantly more serious than this. Now, I realize that what happened here, I'm sad about it. I'm sorry about it. It is, I wish things had turned out differently for the patient. I wish many, many times that things had turned out differently for the patients. I've had many friends die of cancer, of liver cancer and the rest. Maybe I wish that something had been different or not, but I have never thought to blame the doctor for that. They're struggling against a difficult condition. Cancer is a very hard thing to control, but I've had so many friends who have died from these terrible maladies, and it breaks my heart, but I haven't just gone after the doctor with some kind of suit. There's something different about it. So post hoc ergo propter hoc, so Latin phrase that after something happens, it must have been because of something. And you just can't automatically take an admittedly sad outcome and throw overboard questions of law and go after physicians. I don't think the Supreme Court's law leads us in that direction. Okay. If my colleagues have any questions, we'll move into our last case here.
I don't have a question, but I do want to at least express that I'm in agreement with Judge Wilkerson in the general case. This is a case that presents far more reaching issues. This individual is in prison. He develops hepatitis C. He has a liver disease that's progressively getting bad. It is very aggressive. This doctor, on 2 occasions, could have, if he had read properly the guidelines that were before him, sent him for proper treatment. And yet, by the time he did so, it was too late. This is not a cancer case where we got conscious treatment going on. I'm sympathetic to that all the way. But I don't believe in blaming doctors for that kind of thing. And I don't know how it turns out. But at the end of the day, the question is, should the jury decide this man is not a criminal? And that's just a comment. I wanted to make sure we left with the court that we're not insensitive to doctors and what they do out there. But we are mindful of our duties as judges when we put people in prison and they develop terminal type illnesses, this magnitude, that continue to progress because the doctor says, I made a mistake. Well, one mistake might cut it. But the liver disease was getting worse and worse. And it got to the point by the time he got it, too late. So I just want to add that comment to the record because I think it's important for us to do this with eyes open.
Well, I want to just say that I'm accustomed, as always, to giving my dear friend and colleague, Judge Wynn, the last word. And I want to thank both of you all 3 of you on the different sides of this case for your good arguments. And the court appreciates it very much. And we'll move directly into our final case.
Thank you.
May it please the court, your honors, I am Ronald Darwin Ritchie, counsel for the petitioner. Sorry, I take this off. Easier. I'm counsel for petitioner Maria Morales. Petitioners propose 3 particular social groups meet the particularity and social distinction requirements inter alia. Her 3 PSCs are 1, family; 2, El Salvadorian women who are in a domestic relationship they are unable to leave; and 3, El Salvadorian women who are witness to gang criminal activity and are targeted because they filed a police report. One of the elements to qualify for asylum is that petitioner could establish that they qualify if they're a member of a particular social group. And we believe that
what makes them socially distinct to the Salvadorian public?
Well, socially distinct is, each one of these PSCs, of course, has to be analyzed, individually. This court has repeatedly held that the PSG of a family-based.
Where in the record do you find evidence to support that assertion that they are socially distinct to the Salvadorian public?
Well, first with family, Your Honor. This court's recognized that it is cognizable that a family-based PSC is socially distinct, among other things. And
I was speaking specifically to your assertion about the Salvadorian women who were witnesses to gang criminal activity and reported it to the police.
yes, well, this court in Crispin case held that family members of witnesses of criminal activity.
Well, maybe so, but to follow up on my colleagues' questions, socially distinct and social distinction, it's not enough that the group itself thinks of itself as socially distinct. It has to be regarded as socially distinct by the society at large, not just by the group's membership. And that's where the evidence is simply lacking. And the reason you run into a problem with social distinction is that people are targeted, not just the group that you pose, but people are targeted regardless. They're just targeted by gangs for many, many different reasons. And so your proposed group sort of bleeds into the society at large, that the society at large wouldn't recognize this as socially distinct. They would think of the society at large, would think of the situation of, we have a terrible problem with gangs and with violent, brutal behavior for many, many reasons, not just the reason that you posit. So it just, I mean, this is all very loose.
Well, in that regards, just the Home Society in El Salvador does recognize these different particular social groups that we propose as being distinct and are identifiable. There are limiting language in these proposed PSCs and regarding the gang criminal activity. In this case, this case is distinguishable by cases that, for example, the respondent has mentioned, in that you have women, which is one limitation. They witnessed the activity, but they also filed a police report. And in this case, factually, the petitioner filed a police report twice. And plus, she was there when the gang came in and they threatened to kill her. The State Department report does mention that does discuss about witnesses and how witnesses of gang activity, criminal activity, that the government does try to protect them, try to help them, but they're not very successful in El Salvador at that. So that is evidence factually to demonstrate that these PSCs are socially distinct.
I just didn't see the evidence in the record that the society at large regarded this as a socially distinct group. It seemed to me that the proposed group is just one manifestation of a larger societal problem, not a socially distinct group, but simply part of a large a very large landscape of highly regrettable gang activity and retaliatory conduct for every reason under the sun. And don't just retaliate for failure to file a report, retaliate for failures to pay money, for intruding on their territory, for disrespecting them in the way that they are looked at, or what have you. But retaliation is a general means of conduct for these gangs. And that's the phenomenon. And to sort of pick out this subgroup and that subgroup and say they're socially distinct, I don't see the evidence for it. And I think it goes against our precedent explicitly that there has to be evidence of social distinction.
Well, yeah, we agree that definitely social distinction is one of the requirements, but we believe that the facts do demonstrate that the witnesses who filed a police report, that they are considered by society in El Salvador as socially distinct group. They're different than individuals who have just witnessed gang activity or been victims of it. You have this particular language or limiting language in the PSC that they filed a police report. And we concede that this PSC is the more challenging of the other two, but the petitioner doesn't have to show that she meets or falls within all three of the PSCs that she's proposed. Granted asylum.
Normally when these cases come up to us, the stronger ones at least present evidence that the IJ or the finder of fact regarded the asylum applicant as a credible witness here. But here the IJ is noting all kinds of inconsistencies in testimony, and there's no finding that the testimony is credible. And then when you get to these allegations, you find yourself wondering, did any of this stuff, there's no credibility finding that would aid your client, I don't believe.
Well, the precedent decisions are that if a judge doesn't make a specific credibility finding, then the petitioner is deemed to be credible. And the board in this decision didn't question whether the petitioner was credible or not, and therefore we have to presume and assume that the petitioner was credible in general, and the board doesn't question that in its decision.
Don't have to presume that in view of inconsistencies in the testimony.
Well, the IJ, the immigration judge, did mention that there were some inconsistencies, but he never made a determination that she was not, or he did not make an adverse credibility finding. Therefore, she is presumed to be credible without a specific adverse credibility finding having taken place.
Richie, can I ask you about the other two PSGs? Because I think you said that you thought those were stronger. So let me start with the proposed group of Salvadoran women in a domestic relationship they can't leave. Why do you think that's a stronger PSG than the first one you talked about, given the fact that one of the folks that was abusing her died, and the other one apparently left her home about 40 years before. So doesn't the record evidence suggest that she is not, if she may have been in a relationship that she couldn't leave, but she's not any longer?
Well, we believe that the focus of the law is why was the individual targeted? You know, how did they suffer persecution? Not something after. Arguably, everyone leaves a relationship at some point, whether it's by death or some other means. Most of these individuals, asylum applicants, come to the United States. Most of them do not come with their abusive partner or abusive family member. So all of them, if you will, leave that relationship at some point. We believe the focus should be on the harm, the suffering, and why.
Well, but isn't there no point of granting asylum or other protection to ensure that the SLE, the petitioner in this case, is in fact protected from harm? And if, as a factual matter, that's no longer the case in her home country, why would the United States grant asylum on those facts?
Well, a couple of reasons. If for no other reason, one is humanitarian asylum. If all that she has suffered in her country. But I want to go back to your previous question. In the administrative record, it does state that her cousin who had raped her previously, he approached her just right before she entered the country. And that's on the administrative record 87. So it was, her cousin on the still there. In terms, she is likely again assaulted, raped by her cousin. And we rely for this PSG on the my notes. The board's decision in matter of ARCG, where they found that domestic violence women victims that they can qualify that is a cognizable PSG. In that case, that woman had left the relationship. She'd come to the United States, and the board found that was still qualified. The language that it's unable to leave the relationship. In this case, you also have, that the petitioner's partner, he's a longtime partner, and they have a child together. Yes, he's deceased, but she has, she has suffered harm based on her in that particular social group of family.
Counsel, you have some time for rebuttal, and if my colleagues have questions, that'll be one thing. Otherwise, we'll look forward to hearing from you in rebuttal.
Thank you.
Ms. Singer, we'd be happy to hear from you.
Good morning. May it please the court. My name is Jennifer Singer, and I represent the United States Attorney General, the respondent in this matter. I think the primary question before this court is whether a petitioner's social group, specifically Salvadoran women who are witnesses to gang criminal activity and who have reported to police and are targeted because of that, meets the requirements for particularity and social distinction. And I think the answer to that question is no, it does not. As to particularity, at its core, particularity requires that a group be defined with clear boundaries, and it needs to be clear who is in that group and who is not in the group. And the particular social group here, again, Salvadoran women who are witnesses to gang criminal activity and who have reported to police and are targeted because of that. It does not consist of definable boundaries, and it's unclear who is within that group and who is not in that group. And we know this just by looking at the words of the proposed group. Witnesses, we know from Herrera Martinez that it has two different meanings. It could mean someone who has knowledge of something or someone who has to testify under oath. So we know that term is ambiguous. You add the phrase gang criminal activity to that term witness to modify. I don't think it does much to clarify the group. It could mean someone with knowledge of gang activity or someone who testifies about gang activity. And criminal activity is also overbroad. Does it mean someone reports or is a witness to a gang member who jaywalks or who speeds or who litters, or does it mean something a lot more severe?
The whole, excuse me, the whole difficulty with this case, and it sort of runs through all the different alternatives, PSGs, is it's all just very vague and loose. There's not sufficient evidence in the record supporting some claims. There are inconsistencies in testimony. There are questions about what the boundaries of the group are or whether petitioner even fits within them. It's just looked at in its totality, it's just a very vague and loose case, and the statute requires some degree of precision.
I agree. I mean, in terms of the social group of Salvadoran women where it witnesses to gang activity, yes, I think that's very vague. As to the other social groups, I don't think there's any vagueness at all. With regard to the family, that was disposed of on nexus grounds. And with regard to people in a domestic relationship that you are not able to leave, I think it's clear that petitioner is not a member of that particular social group. So I think those are pretty clear. But in terms of vagueness, yes, this group of witnesses to gang criminal activity is very vague, and particular social group requires particularity. And almost by definition, this group is vague. It doesn't have that particularity that is required. Even the word gang is ambiguous. In Amaya, the court made it clear that because MS-13 was used to describe the group, it was clear and unequivocal what the group, who that group was. Here, gang is somewhat ambiguous. And then the phrase "who have reported to police," I mean, it's unclear what that means. I looked up our reporting on the internet, on the Merriam-Webster dictionary. Says to report means to give an account of, i.e. to tell, to be present, to present oneself, or to make, issue, or submit a report. So under those definitions, the social group could include someone who just tells the police something or presents herself at the police precinct and discloses something, or actually writes a formal written report and then presents it to the police. And then even within those separate definitions are even more questions. That includes someone who called 911. Does that include an anonymous tipster? Does that include someone who just told police something at a crime scene? Does that have to include someone who actually goes to the police station and makes a statement? You have to file an actual report. You file a complaint. It just is really unclear who falls within this group and who doesn't fall within the group.
You know, Counsel, I think you've made these points very ably in your brief, and we appreciate that. And maybe at this point, the best thing to do is to ask the panel if they have any questions of you. Judge Wynn, do you have any questions?
No, I'm satisfied with the rest of the briefs.
Judge Diaz? The panel has no questions. We appreciated the quality of your briefing and your argument. And thank you very much.
Thank you, Your Honor, and I'll just rest on the briefs. Thank
you. Just a couple of points here. The respondent focuses primarily on one particular social group. As I noted earlier, the petitioner only has
can be successful if she can establish that she is a member of one particular social group. It doesn't have to be all three. And so we believe that she does. And I think the respondent concedes that that her family-based PSC is cognizable, socially distinct, and particular and immutable, and that her domestic violence, or being a victim of domestic violence, and is cognizable. And they mentioned about nexus. Well, and they argue in their brief that the partner raped and beat his partner continuously over at least a 10-year period, not on account of her gender, not on account of her being his domestic partner. I believe that's incredulous to make that argument, because there is no evidence in the record to show that her partner went out and did this to other women in El Salvador, in the society. The only evidence is that he did this to this woman because she was his property, and he felt and believed that he could do whatever to her, and it didn't matter because she was his property. So we believe that the government is misplaced in its argument that there is no nexus.
What's the, Mr. Ritchie, what's the evidence of that? I mean, that's a compelling argument, but what's the record evidence that that was the motivation?
Well, one thing, if you look, actually, there was a pattern. He was doing this on and on. Her partner was using her, was raping her. Even when she tried to leave, he went out and brought her back. Well,
but I think the question my colleague goes, we don't know if these accusations or allegations are even true, and I'm not sure whether they are or whether they aren't, because what reason is there to believe that she was treated this way because of family? The government suggests that jealousy or possessiveness or sexual desire, or there may be a lot of reasons that this happens, and we have to take into account the on account of and because of language in the statute. And if this, I don't know what happened or what didn't happen, but there was no evidence that it happened because of family membership.
Well, they had a child together. Okay, they lived together for at least 10 years. I think that establishes that there was a domestic relationship.
Well, I mean, but there are a lot of men and women that live together for long periods of time, and during that period of time, they engage in sexual relations, but that doesn't that the reason or motive for those relations derive from the alleged victim's membership in a particular social group.
Well, yes, we can't see into the perpetrator's mind. We can only, assess based on what happened.
It's your burden. It's your burden.
Sorry?
It is your burden to establish nexus.
Correct.
At any rate, counsel, I think we do understand your position, and we appreciate it. Thank you for your argument, and I want to thank Ms. Singer for her argument as well. We're very grateful to you both.
Thank you very much.
All right, I will ask our courtroom deputy, please, to adjourn court, and we will take a 5-minute break and give the courtroom the clear, after which we will conference.
This honorable court stands adjourned, signed, die. God save the United States and this honorable court.